Good morning, everybody, and welcome to the new series of Quadcasts from Quadrant Chambers. On Thursdays at 5 o'clock, our Quadcast team are going to be discussing, well, actually we tend to argue more, but discussing the latest hot developments in commercial litigation generally. And on Tuesdays at 11 a.m., we're going to have some special shipping quadcasts where we're going to discuss issues of particular interest to the maritime community. So here we are at 11 o'clock on Tuesday, and what we're going to be discussing today is the recent decision in the Eternal Bliss that was handed down in September. So let me introduce you to the team for today. There's me, Poonam Melwani, Chirag Karia, Ruth Hosking, and Andrew Carruth. Morning, everybody.
Hey.
Morning.
So, paragraph 1 of the judgment in the Eternal Bliss opens by explaining that the case provides an opportunity to settle a long-standing uncertainty on an important point of law in the shipping world. And the problem is a scenario with which we're all very familiar. You've got a voyage charter party with laytime and demurrage provisions, and the loading or the discharge of the cargo is taking ages because there's port congestion or there's lack of storage facilities. So the vessel's on demurrage, fine. But now imagine that because of the delay, the cargo deteriorates. So in the Eternal Bliss, it was a cargo of soybeans that started to cake and mold. And this postulate, this deterioration is not because of anyone's fault. It's just that the cargo has a limited ship shelf life. So the owners get demurrage, but can they get damages from charterers for the damage to the cargo? Because, for example, they might have to indemnify the cargo owners under the bills of lading contracts, or for any other losses they might suffer because of delay, where, and this is the important point, the only breach that charterers are guilty of is a breach of the laytime provision. So this was the question before the court in the Eternal Bliss, where, interestingly, the parties agreed that the commercial court could decide the point of law under Section 45 of the Arbitration Act, rather than having gone through the arbitral process first. So to find in favor of owners in the scenario I've just postulated would require the judge to have said that previous decisions were wrong or previous decisions were misunderstood. And that is exactly what Mr. Justice Andrew Baker did do, finding in favor of owners, no doubt because of the brilliant submissions by Tom Bird of Quadrant Chambers. We're going to discuss the case in detail, but to understand it in context, we are going to have to make sure we understand laytime and demurrage provisions, and I'm going to ask Chirag to talk a little bit about that. But before I go to Chirag, can I just say to all our viewers, do please join in with us. There's a Q&A button somewhere on your screen, and if you could send us your thoughts, observations, disagreements, and if you have some short questions, we'll see if we can answer them during the course of this. But Chirag, over to you.
Thank you, Poonam. Well, I'm sort of very diffident in what I'm going to be talking about because I'm going to be taking it to the very basics. What is laytime and demurrage? And the reason we need to look at that is because it's on the definition of those concepts that the judge initially determines his answer. So laytime, as we all know, is the period of time that a voyage charterer is allowed to carry out cargo operations. And demurrage is the amount, daily sum, that the charterer has to pay for exceeding the laytime. Now, an important question is, what is the nature of demurrage? And the House of Lords decided in the Lits that demurrage isn't the price for that extra time, but it's actually liquidated damages for the charterer's breach in exceeding the laytime. So when you exceed the laytime, you are in breach of charter. And the only thing that demurrage does, it simply says, this is the fixed amount you get for breaching that term. That leads to the question of, what is it that demurrage is compensating the owner for? Is it for all consequences of the breach of the laytime provision, or is it only for certain types of losses? And if it's only for certain types of losses, what types of losses are covered by the demurrage clause and what losses fall outside that coverage? And more importantly, how do we know? How can we tell by reading the Charter Party which losses are and which losses are not compensated by the demurrage provision? Now, there are numerous dicta in all the cases. In the House of Lords, the dicta suggests that demurrage is the liquidated damages for detaining the ship beyond the stipulated lay days. That would suggest that it covers all loss resulting from breach of the lay time limit. Alternatively, Lord Justice Diplock in Swiss Atlantique said it was to compensate for the inability to earn freight. Now, there are various different types of losses, and I think Ruth's been looking at some of them and we'll discuss them.
I mean, obviously, some of them are more obvious than others. So in relation to the vessel itself, the most obvious is the loss of the vessel's freight earning ability, because it's an asset which owners use to make money. You might get loss in relation to the next employment because it misses its next laycan, or an employment after that one. You might get damage to the ship itself. So a prime example would be hull fouling if the vessel's detained in a tropical port for a really long time. You also then obviously get losses to the cargo itself. So the Eternal Bliss is an example of that. It's cargo deterioration. In that case, it was soybeans. Many of us have probably seen quite a lot of losses in relation to avocados. I think one of the old cases looks at garlic. And in fact, I think, Poonam, you had an interesting case involving the deterioration of garlic, didn't you?
Yeah, thanks for this, Ruth. So I think I was about 2 years old in practice, and I had a case about garlic deteriorating due to the excessive length of the voyage and discharge operations. And I was cross-examining the expert on this particular day, and I wanted to be dramatic. So I had this big plan of, during my cross-ex, chopping up some garlic in front of him to show the inside deterioration. Anyway, I didn't think this through very clearly, because as I go through security in the Royal Courts of Justice, bah, bah, all the bells go, because I've got this knife with me, which obviously wasn't allowed to have. So I got dragged away and had to wait while the clerk to Mr. Justice Hobhouse had to come down, take custody of the knife, vouch for me. Mr. Justice Hobhouse was furious because of what I'd done and because the trial started late. But the good news was he did let me use the knife in my cross-ex, and I had lots of fun. Thanks, Ruth.
Great. And moving on from that, cargo can become more dangerous, does not your barrister in a trial? So some cargoes are time sensitive, and the longer they're on the ship, the more dangerous they become, and there might be costs associated with that. You might have costs associated because you're carrying refrigerated cargo, and there's costs. We don't talk about it very often, but there's still an awful amount of livestock carried on ships. And what happens if your cargo happens to be cattle or sheep and you're stuck for a really long time? There will be animal welfare costs and feeding costs, that sort of thing. There are obviously also slightly more obscure types of loss. So, for example, if when you arrived at port it was summer and you've been there so long it's now winter, you might need to change and therefore only load up to your winter draft, and therefore there might be a loss associated with that. I think one of the earlier cases that Chirag will be talking about, in fact, had that as its factual scenario. So there are lots of different types of loss that we might have. And certainly traditionally, I think as counsel and solicitors, we'd always be looking to find other breaches that we would then be pleading, at least in relation to those losses. So, for example, in the one I've just mentioned about the summer and winter drafts, you might be pleading a breach of failure to load a complete cargo. In relation to dangerous cargo, you might be looking at some of the warranties and conditions to do with that. And obviously the hull fouling, there's often separate individual clauses. So those are all the sorts of types of losses and the types of breaches. But as Poonam said at the beginning, I think the reason this case is so important is that it's a single breach case. And I think, Andrew, you've got a useful graphic that shows that to us.
Yes, exactly. So, I mean, as you say, Ruth, and as Chirag said, there are sort of these two issues that one has to bear in mind. The first is, how many breaches are we dealing with? Is this a one breach case where the only breach is failure to complete cargo operations within the allowed lay time, or is there another separate breach that can be identified? And the second issue is, how many heads of loss are we dealing with? Is the only loss detention of the vessel, or is there some other loss being claimed? And there are sort of four different possible combinations of those two issues, which the judge set out neatly in a table, which we're just going to have a look at. So you see here the table, and on the left-hand side, we've got how many breaches, and then across the top, we've got how many heads of loss. And then in the table, we've got the 4 possible combinations. Starting with the top left, where you've got 2 breaches or more than 2 breaches, and you have another type of loss, not just a tension of the vessel, it is possible to recover damages in addition to demurrage. And you'll see there reference to the case of Reader and Arcos. As Ruth said, Chirag will talk about that in a minute. But that case said that you can recover even where the second breach has been caused by the first breach. So in that case, it was loading delays causing a failure to load a complete cargo. Moving to the top right, where you've got a separate breach, but the only loss claimed is detention of the vessel. And that's sort of the opposite of what we're dealing with in the Eternal Bliss. It's the opposite factual scenario. And their recovery is not possible. 2 cases on that, Inverkip and Bungy, and Chandris and Isbranson Moller. Bottom left, a 1 breach case, but there is loss claimed for other than detention of the vessel. And that is exactly the factual scenario in the Eternal Bliss and the issue the judge had to decide. And then finally, in the bottom right, we have no separate breach and no other head of loss claimed except detention. And pretty much unsurprisingly, it is not possible to recover anything other than demurrage in that situation.
It hardly needs its own box.
No, it's quite, and it certainly doesn't need reference to authority, but there we go, it completes the table. So just getting rid of the table, there are a lot of cases referred to, a lot of prior authorities referred to in the judgment of Mr. Justice Andrew Baker. But before he went through those meticulously, he sort of decided to step back and look at the issue from first principles, look at it afresh. Poonam, do you want to just talk us through what he thought about it himself?
Yeah, so on the first question, have we got 2 different types of loss, which was your right hand of your table that we just looked at. And Ruth's been talking about the different types of loss, and I mean, instinctively, we'd all say your vessel being delayed is a different type of loss from your cargo being damaged. That doesn't seem like rocket science. But the argument for charterers was, well, yes, you felt the loss financially in different ways, but it's really the same type of loss because both losses are caused by delay. Delay is your touchstone, and since they're caused by delay, you shouldn't be able to claim separately. It's part of the demurrage. But Mr. Justice Andrew Baker had very little time for that. I think he said it was almost incomprehensible. And he said, no, these are 2 different types of losses. So we're on to the left-hand side of the table. So as to that, do you need 1 breach or do you need 2 breaches? The way Mr. Justice Andrew Baker approached it was he said, look, demurrage is the liquidated damages for loss of the vessel as a freight earning instrument. It's the daily rate is almost a proxy for the loss of revenue. So that's one type. But you can have different losses from 1 breach. That's trite law. You can have different types. And he said the Swiss Atlantique, which Chirag mentioned earlier, made pretty clear from their House of Lords that demurrage is not an exclusion clause. It does not say this is your only remedy for breach of the laytime provision. So you can get money for other breaches, and so you can get this other claim. He accepted that life would be very certain if demurrage was the only remedy you could get, but he said the current contracts, and in Eternal Bliss, it was the Norgrain form. He says the existing standard forms don't make that clear, and if parties want to make that clear, they can insert suitable wording, but absent specific wording, you can claim for other financial losses from the breach of the laytime provisions. But he says all of that from first principles, ignoring previous authorities that had discussed or touched upon the issue that we're concerned with. And the problem is, Chirag, there are quite a lot of those other authorities that he had to grapple with.
Indeed, there are. And what I'm going to be talking about are the 2 appellate authorities, which arguably, or certainly was argued, were binding on him. And the most important of those is Reader and Arcos, a decision taken in 1926, so 94 years ago, And there, what had happened is the vessel had arrived at the load port in sufficient time to load a full summer deck cargo of timber. But because of the delay in loading, she was only able to load the lower winter up to the winter limit. So the charterers obviously paid demurrage for exceeding the lay time, but the owners said, well, that's not enough. We actually want dead freight, because if you'd loaded in time, you would have loaded a lot more and we would have earned a lot more freight. The charterers, of course, demurred and said, well, look, you've got your demurrage. We were late. We've paid you for that being late. And the Court of Appeal, and before that, Mr. Justice Greer at first instance, looked at the contract. The contract provided the usual lay time regime, and which required loading within lay time. There was also a provision that required the charterers to load a full and complete cargo. The Court of Appeal unanimously held that the owners were entitled to recover the dead freight in addition to demurrage. But the reasoning of each of the Lord Justices was differed. Lord Justice Banks placed it simply as a one breach case. So it was the breach of the lay time provision that led to this loss, and this loss was recoverable in addition to demurrage. Lord Justice Atkins said that this was a breach of the duty to load a full and complete cargo, albeit it had been caused by a breach of the lay time provision. And Lord Justice Sargent simply said this was a breach of the duty to load a full and complete cargo. Now, what the judge said in the Eternal Bliss is this case doesn't tell you whether you need two breaches or whether one breach is enough. Because although the majority held that there were two breaches in that case, none of them said you need two breaches. So it doesn't tell you either way, the judge said, what the answer should be in the Eternal Bliss. He also looked at the Swiss Atlantique, but if you actually look at the facts of that case, it's a straightforward application of the invocate rule, that if the only damage you're claiming is for the detention of the vessel, then you can recover no more than demurrage. In that case, it was a little bit more complicated because it was a multi-sequential number of voyages. And because of delays in cargo operations, there had been fewer voyages performed than would have been. But if you actually look at it, that is still a detention claim and a claim for loss of earning capacity, which is compensated exclusively by demurrage. The dicta in the House of Lords are very Delphic, and they compress issues of causation and the type of loss, so they don't really tell you much. So neither of those cases really is determinative. And then Andrew is going to be looking at the later cases, one of which was determinative of this issue. Andrew.
Yes, that's right. So, I mean, the appellate authorities leave us in the mid-60s with Swiss Atlantique, and then bringing us up to present day are three other cases, all of which were first instance judgments. The first was the Altus in the mid-1980s. That was a case where, somewhat unusually, the demurrage rate was linked to the quantity of cargo loaded. There were delays in loading, which meant a full cargo wasn't loaded, so the demurrage rate was lower than it otherwise would have been with a full cargo. And one of the losses which the owners sought to recover from the charterers was the difference between the demurrage rate which in fact applied and the demurrage rate which would have applied if a full cargo had been loaded. And Mr. Justice Webster said, yes, you can recover that loss in addition to demurrage. But an essential part of his reasoning was that this had already been decided in Rita and Arcos, and that the Court of Appeal had said there that you didn't need to establish a separate breach. And what Mr. Justice Andrew Baker said in the Eternal Bliss is, well, that's simply an incorrect reading of Rita and Arcos. That was a two-breach case. And as Chirag's already said, it doesn't tell us what the answer is where there's only one breach. Secondly, there was the Adelpha in the late 1980s. That was a case about a cargo of maize being carried to Libya, which arrived with a small amount of wet damage. The owners settled some cargo claims brought by the receivers and then sought to pass on that loss to the voyage charterers. And it came before Mr. Justice Evans by way of a Section 69 appeal on a point of law. There was some obiter discussion of Rita and Arcos. But in terms of the issue, which was the key issue in the Eternal Bliss, the judge didn't actually decide it. He simply said he was willing to assume that it was possible to claim more than just demurrage where there's only one breach, but he didn't actually need to decide the point. So that case doesn't really take us any further. Finally, then, there was the bond in 1991. That was a case about a contract for the sale of wheat on FOB terms.
Hang on, can I just ask you, say finally, so that's like 30 years ago. There's been no judicial comment on this point in those 30 years?
Yeah, that's exactly right. I'm not aware of any other judicial comment. Things rested with the bond for almost the entirety of my life. So, yeah.
There was a small comment in the Luxmar, but I think...
You're right, you're right.
Correct, yeah. Sorry, it was a contract for the sale of a cargo of wheat, FOB terms. The sellers had to meet a specified loading rate, and if they failed to meet that guaranteed rate, they had to pay demurrage to the buyers. If the vessel failed to file at the load port within a certain specified shipment period, the buyers had to pay carrying charges to the sellers, and that was a carrying charge per day from the end of the shipment period until loading was completed. What actually happened in the event was that the vessel filed after the end of the shipment period and the sellers failed to meet the guaranteed loading rate. So the sellers were liable for demurrage, but the buyers were liable for carrying charges. And what the buyers said was, well, we shouldn't have to pay these carrying charges for the period of time when the vessel was on demurrage, because we can claim those as a loss flowing from the failure to meet the loading rate guarantee. The seller's answer to that was to say, well, no, all you get for that breach is demurrage and you can't claim any other loss. And that was the issue which came before Mr. Justice Potter in 1991. And he sided with the sellers. He said, that's right, all you can get for breach of the loading rate guarantee is demurrage, and you cannot claim any other loss unless you can show a separate and independent obligation. But the sort of critical part of his reasoning was that this is what the House of Lords had held in Swiss Atlantique. And so he effectively thought he was bound to reach the same conclusion. But when one looks at the speeches in the House of Lords in Swiss Atlantique, they say no such thing. And that's exactly what the judge said in the Eternal Bliss. That's simply a wrong reading of Swiss Atlantique. It doesn't decide this issue. So, I mean, as we've already discussed, apart from the one minor comment in the Luxmar, this is where matters have stood since 1991. I mean, Ruth, in your view, is this the settled view since 91, or has it been open for debate?
Yeah, I mean, just dealing with the Luxmar while we've mentioned it, the judge in the Eternal Bliss just said it was unnecessary and wrong to have relied on the bond. So there's partly because in the Luxmar itself, very little is said about it. It's like sort of one line somewhere along the line. And what I think is really interesting in the court's judgment in the Eternal Bliss is what the judge says at paragraph 144, which is in relation to whether there's a settled view or not. I mean, you might think, given that the bond's been around for the best part of 30 years, and Andrew's obviously pointed out he's younger than all of the rest of us because it's been his entire lifetime. He said, practitioners and their owner, charterer and insurer clients, if they do not rely on external legal advice, will first turn to Scrutton and to void charters. And then he refers to a particular article by Robert Gay from the mid-2000s. Now, I mean, I would love to know if there are any charterers, owners or insurers on today and what they think, but I can't imagine anybody before entering into a contract would have looked at Scrutton or any of the textbooks about this, and certainly wouldn't have read the bond. And most of them, certainly in my experience, don't come and ask for legal advice in advance of entering into the contract. I think we've probably all looked at this point perhaps when pleading a particular case for alternative damages. So I think what's really interesting is that it's sort of assumed that everybody knew this, that there was a debate in a way that I'm not really sure that people on the ground, when they fill in the little demurrage box and pick their demurrage rates, were even thinking about it.
Well, I mean, because that's... Go on, Chirag, go ahead.
Also, Ruth, would you not agree that when the issue is raised, people would normally go to the bond and say that settles it? I mean, I'm not sure that certainly I wouldn't necessarily go to all these erudite articles if you're in arbitration and you have a first instance decision on point.
Well, and I'm sure that there are plenty of arbitration decisions that have been dealt with just on the bond. And I suspect also there are many of these cases that have never gone to arbitration because someone does a demurrage calculation, you pay your demurrage and you move on.
And actually, I mean, Andrew Baker puts a lot of emphasis on Scrutton being one of the books that says that owners should be able to recover. But he's got a passing reference only to this, and I checked them last night. All the editions of Scrutton since the bond fail to mention the bond.
Well,
If you went to Scrutton as a lawyer, as he thinks, and I'd just say, well, Scrutton's wrong because he hasn't kept up with the law, so I wouldn't pay any attention to it. But as you say, yeah, I agree with you, Chirag. Why would you not get arbitration and be bound by it? The arbitrator would say he was bound by the bond.
I mean, it's very helpful for us that we have the eternal bliss, but certainly from the charter's perspective, it's difficult to see what was the advantage of going to the courts rather than just going to arbitration, saying to the tribunal, here is the bond, it's binding on you, just decide it. And then, you know, let the owners try to get Section 69 permission if they can.
Yeah. Ruth, did we cut you off midway?
No, not at all. I think one of the interesting things is that there hasn't, because of the way it's ended up in court under a Section 45, you don't know whether the tribunal would have taken sort of effectively their judicial notice of what they would have done, because a lot of them were brokers, for example, and just thought that this was a settled position. And similarly, there wasn't any evidence before the court about, on the ground, what people were doing. And I do wonder whether causation and remoteness might be the tools with which, at least in respect of those contracts which is already in existence, rather than ones that you can now add a comment, add a clause into. Maybe that's the way that, certainly going forward, we might seek to argue them if we're on the side of charterers.
Yeah, and I should say, Tom told me that Andrew Baker has given permission to appeal to the Court of Appeal. And of course, if he'd refused permission, the Court of Appeal would have had no jurisdiction to grant it. But he's given permission. And again, I'm told, saying that he was quite sure the Court of Appeal would agree. He wasn't giving permission because he thought there was a real risk he was wrong, but that he recognized it would be good if this important point was settled going forward. And we would be interested, actually, we've had a few questions from our viewers, which we'll come to, but I'm assuming that with COVID, and I mean, I know some examples, delays in discharging and loading, and therefore the very breach of the laytime provision we're talking about is increasingly common and causing all sorts of losses. So this is, going forward, a very important point. Okay, so guys, we've discussed a lot of authorities, and we thought it might be helpful to summarize them for you. So if I can remember how to share screen. Have you got that? Can you all see that?
Yes, so
Right.
Reader and Arcos decided that whether it's 2 breaches or 1 doesn't tell you, because that happened to have 2 breaches, but that wasn't determinative. Swiss Atlantic was not on point.
The Altus, the analysis of Reader and Arcos was wrong and the case is unreliable. The Adelpha, it's irrelevant because it didn't hold that 1 breach is sufficient.
Then going to the textbooks, what Mr. Justice Andrew Baker said was that Voyage Charters was wrong because it said Swiss Atlantic required 2 breaches. Said that Schofield didn't help because it didn't have a principled position. Carver was wrong because it said that even before the bond, you needed 2 breaches. McGregor, also like Schofield, has no principled position. And Chitty, my Bible, apparently adds nothing to the debate whatsoever.
You then get the bond, where the reasoning is clearly faulty, and Mr. Justice Potter was clearly wrong, and the Luxmar, which was unnecessary and wrong to have relied on the bond. So we end up back at first principles.
And that means that the winners are Scrutton, notwithstanding the failure to mention the bond. Robert Gay for his 2004 article in the Lloyd's Maritime and Commercial Law Quarterly, well done. And somewhat unsurprisingly, Mr. Justice Andrew Baker.
Okay. Sorry, Chirag, were you going to say something?
Well, as far as whether Mr. Justice Andrew Baker is the winner will be determined by the Court of Appeal, I think.
True.
Right. Okay, so we've actually had a question which relates to something else I was thinking about too. So let me give you guys a scenario. Lay times exceeded, discharge taken way longer than expected. Owners are getting their demurrage, fine. Eventually, the cargo is all discharged, lay times comes to an end, the charter's at an end, vessels being redelivered to owners. But because of this delay, this port, which has a propensity to get iced over in November. Because of the delay, we're now in November instead of the preceding month. It's got icebound, and the vessel's now stuck in the port and can't leave the port and can't earn freight. Only breach is breach of the lay time. So first question, do we agree that owners would be able to claim, I'm just going to put this generically, claim money for days that they are delayed in the port, even though the vessel's been redelivered to her because she's been stuck there? Do we all agree that they have a claim in principle? Anyone disagree?
Yes.
Yes, you disagree, or yes?
Yes, I agree.
Thank you, Chirag. Right. The trickier question, and this is one that one of our viewers has asked. They've said, well, if we're in detention, is it the detention rate or is it the demurrage rate? So here's the question. For the period it's stuck after redelivery back to transport, it's stuck because of the breach of the lay time provision. Is it the demurrage rate or is it detention market rate if owners can prove the market rate is more at that time? Who wants to go first with their views?
Sorry, just by it's been redelivered, you mean post-discharge? Discharge is completed, I should. Yeah, okay. Yes.
So I think at that point, demurrage ceases to be the agreed liquidated damages, because they only apply during cargo operations. And then you have damages at large. So it's the market rate, I believe.
I mean, I instinctively think that's right. I think it is the market rate, but I'm very aware, having seen this pleaded a lot, that you often pleaded a separate breach in relation to detention as opposed to simply the breach of the lay time provisions. And so it will be interesting to see how parties argue it post the Eternal Bliss, whether somebody's going to be trying to argue it's the demurrage rate. I mean, the demurrage rate often got used because people said, well, it's the equivalent of a market rate without getting market evidence. But instinctively, I think that they ought to be at large, and they traditionally have been, but whether the analysis for that is the same, I don't know.
Okay, so a cautious agreement with Chirag is how I describe you, Ruth. Where are you, Andrew?
I'm going to give you the Lord Roger answer. I agree, and there is nothing I can usefully add.
Ooh.
Okay, well, I mean, I see all of that, and that was my sort of original thought. But what's just concerning me is the two breach point. And I guess it's how you define demurrage. Yeah, Chirag described Swiss Atlantique, and I wrote it down. You said Swiss Atlantique said that the demurrage rate is to compensate for the loss of the freight earning. And if you define it like that, well, the damages we've just been talking about, all it is, the type is the loss of the freight earning. And I appreciate the chart is at an end and lay time's at an end. So the question is, does demurrage, can it apply even after lay time's at an end because it's about freight earning? Or flip the question the other way. Yes, you have breach of lay time. Yes, you can get different types of losses where you've got a breach of lay time, but where your loss is loss of use, you're stuck with demurrage. I mean, I can just see the arguments, I think, going forward, and we'll see. Another question, there's one really long question, which I'm not going to be able to read, so someone can take charge of that. I'm going to read my eyesight. Someone younger needs to do it. Okay, a simpler question. Someone concentrate while I read this out. So imagine that, because as Ruth mentioned, that because of the delay, you could get hull fouling. And I think we'd all agree that the costs of clearing the hull fouling or any other results, maintenance costs because of the delay, owners could claim for breach of the lay time. I think that seems reasonably clear. I'm not sure I know the answer to this one, so throw all the views, but let's assume that the vessel had to steam somewhere in order to get the hull clean, go to dry dock. So there was the loss of time as they steamed to dry dock and while they were at dry dock. Would we say they could get that loss of use time as well, which was incurred in order to get the cleaning done? Or would we say that's too remote or some loss of use that's not recoverable? Who wants to go first?
I think that's quite a difficult question. Instinctively, I mean, if we look at it from a first principles basis, you're supposed to put the innocent party in the position that they would have been in but for the breach. The breach is the failure to load or discharge within time. But for that happening, they wouldn't have had to have steamed somewhere to get their hull cleaned. So how you assess the monetary sum for loss of time, instinctively, I think as a matter of first principle, you ought to be able to claim for the loss of time. And on this basis, it ought to be outside the demurrage regime in the same way that the detention damages ought to be at large. But I can see, I mean, great, keeps lawyers in work, but I can see quite a lot of arguments about that going forward as to how you assess it and whether there are questions about mitigation, because there might have been somewhere closer for you to get it done and you've gone up to a particular port because it helps you with your next voyage later down the line. So that's my instinctive thing, but I think it's not an easy answer.
Yeah, I agree with Ruth. I mean, in principle, I can see no reason why you shouldn't be able to recover it. It's a loss that has been caused by the breach. It's a different type of loss because it's hull fouling. Although it's manifested itself in delay, but it's really, you're trying to mitigate the hull fouling problem. So under the Eternal Bliss, you should be able to recover that. And demurrage would cease to be the liquidating that damages because cargo operations are finished. My view.
I think, yeah, I agree with what you've both said. It's interesting there, isn't it? Because well, we were talking earlier about, well, it's loss of freight earning capacity. Here it's the same. She's lost her time, lost her freight as she goes to sort herself out. Yet it seems more clearly that to me that shouldn't be the demurrage rate, which suggests that my answer where I disagreed with you earlier is probably wrong. But there we go, that's the point.
I think the answer to your point earlier was that it's only liquidating loss of use between notice of readiness and completion of discharge. That's the minor refinement to your point that needs to be made. If you look at the period before the vessel becomes an arrived ship, there's authority to say that their damages for detention are unliquidated. So by analogy, I would say the same must be true post-discharge when the demurrage regime ceases to operate.
Although I think there will definitely be some charters, and I think we've had, somebody's made a comment about this, there'll be some charters that have a waiting provision that allows charterers to give orders to wait and that the time for waiting is kept as demurrage. And so, of course, you might give a long, you might get someone there for 30 days, 60 days, complying with charterers' orders to wait, but for which the contract says it's a demurrage rate, not damages at large. I think that was the long question that you were struggling to read,
Yeah, okay, that wasn't very kind, Ruth. But I think that the crux of the question though is, if you're asked to wait for so long, can you just keep it there? Because once on demurrage, always demurrage, or is there a point that the charter's frustrated, or they can claim something else?
Well, those are two different issues. Firstly, the vessel has to remain there until it's frustrated. You can't say, oh, this is past a reasonable period. That's been well decided. The second issue is, can you claim additional loss only if it's of a different type, a type other than the loss of the freight earning capacity of the vessel? That's what the Eternal Bliss decides, unless the Court of Appeal says something different.
And even if you could point to another breach other than the lay time provision, because let's say they were not, let's just imagine there was another breach,
yeah,
you'd still be stuck with the demurrage provision per the invocip, I think, correct?
Exactly. That's right.
Yeah.
Yeah.
Let's take another issue. I think at the beginning, or certainly in the judgment, the judge talks about being able to contract out of this. So if you're now advising a charterer who's worried about the judgment, what sort of wording do we think might assist with that? Has anyone got any views?
Oh, we're all giving way to each other. Go on, Andrew, you have this one.
I don't think it needs to be anything complicated or fancy. You just say, depending on which way you want to go, demurrage will be the exclusive remedy for all losses flowing from failure to complete cargo operations within the allowed lay time. That's all you would need to say, I think, if that's what you want to achieve.
Yeah. So, question, guys, going back to law rather than facts. What do we think? Do we think the decision in the Eternal Bliss is right or wrong? Put your hands up if you think it's right. Ooh, a split. Right, you two who disagree with me and Andrew. Why do you think it's wrong? Chirag?
Well, I have my serious reservations for two reasons. Firstly, where parties have set out a contractual term, the lay time provision, and liquidated damages to be paid in the event of breach of that contractual provision, why shouldn't those liquidated damages be understood to cover all damages that may arise as a result of that breach? You've got a breach, you've got liquidated damages, why don't they go together? Why? And if you do draw a distinction between different types of loss, where within the charter party do you get that distinction? So that's my first point. The second point is, even if from first principles you would say that in fact it should cover other types of losses. Other types of losses should be recoverable in addition to demurrage. I think the bond has stood the test of time for 29 years. There has been no great upheaval within the shipping industry to say that this is causing difficulties. And per the usual view in commercial cases, that it is better that the law be settled than that it be right, because parties can always contract around it. The court should simply keep the position as it is in the bond, and parties can contract around it if they think they want something different.
So actually, Jag, we've actually had from one of our viewers, one of the things we were debating, where what's been said is that the quantum of demurrage, the way in which demurrage is calculated, doesn't take into reflect other losses like cargo damage or whatever. It is a reflective of the freight earning capacity. So demurrage isn't a sufficient protection for owners, and that, I mean, and that's fine.
I'd say two things to that. First of all, the judge didn't have evidence of that. So secondly, why is that still the case, given that the bond has been decided 30 years ago?
I mean, I take a politician's view, which is that it's neither right nor wrong. It's right in the sense that, as a matter of first principles, it must be uncontroversial that a single breach can give rise to multiple types of loss. That, as a matter of contract law 101, that must be right. And similarly, you're supposed to put the innocent party in the position they would have been in but for the breach. I also accept that Mr. Justice Andrew Baker's analysis of the law is right, and that Swiss Atlantique does not say what everybody obviously assumed it had said. I guess my concerns are that this isn't how people have been operating. And if we're looking at assumed responsibility, and I know people don't like the accolades, but that is the wording that the House of Lords used, I'm not really sure that owners and charterers, when entering into these contracts, that the charterers have assumed liability for this risk. And the reason I say that is that they have no idea what other liability the owner may be under, and there is no general limitation of liability for a particular loss. So if they thought that they were potentially liable for anything other than the demurrage rate caused by this breach, you would have expected, I think, commercial parties to have had a maximum liability clause or something in the contract that would have dealt with that. On this basis, charterers are completely unprotected, and their insurers presumably are now going to get claims that they weren't expecting. And so it's it's not that I think the decision is wrong, I just think it's not how I'll be glad to be told I'm wrong by people actually on the ground, but I just don't think that that's how this business has been operating for the last 30 years.
Okay, so look, guys, we need, go on, Chirag, I was going to wrap it up.
Final point, I mean, the owners have P&I cover. Now, charterers may have some cover, they may not. But the owners' P&I cover expect to handle cargo claims. Questionable whether, to the extent charterers expect to handle them in that sense, to actually bear the final loss.
Okay, we're going to wrap it up because I can see we could argue forever. But basically, until the Court of Appeal comes out, if you want to say owners should claim, you know who to instruct, and if you want to say charterers should claim, should when you know who to instruct, and we won't debate it further now. Thank you all for joining us and staying with us. We actually haven't had a drop-off, which is very lovely. Thank you so much. Can I just do a plug for the other podcasts? Day after tomorrow at 5 o'clock this Thursday, the Quadcast team are going to be discussing the Supreme Court judgment in Anchor and Chubb, a split decision between their lordships on how to determine the proper law of an arbitration agreement. We'll also be discussing what we think the Supreme Court should decide in the long-awaited, still-awaited judgment in Halliburton and Chubb, which is going to be very important on the issues of an arbitrator's duty of disclosure and on apparent bias, and which has some real ramifications for our shipping LMAA arbitrations with the string arbitrations. And our next shipping podcast will be on the 3rd of November. So thank you so much for joining us. Goodbye from all of us here, and
Right.
see you soon.